Us back on the property show. Buy, sell, invest in property. This is the space you should be watching out for. 3 cities that we've lined up: Lucknow, Pune and Ghaziabad. But before that, there are always legal and tax issues when buying property. So we bring you India's best experts to take care of that. Today we are joined by Vinay Singh, advocate and founder of Vinay Singh & Associates. Vinay, thanks very much for joining in today. We've got a very long question from Gaurav Gupta in Pune. So let's bring him on. Gaurav, hi. Thanks for joining in. You've sent us a long email. So I'm going to request you to start off by your first question. And then as Vinay answers, we can take more.
Okay. Hi Manisha. Hi Vinay. Thank you very much for taking my question. So my question one is, I am buying my first home. So I am told to sign a third-party agreement with the existing owner and the developer as the other two parties. So my question is this agreement legally okay for me as a buyer? Or will I be the owner of the flat without any right of the developer in my flat?
All right, Vinay, that's a very interesting question. I would wonder, why does he need to sign a tripartite agreement at all? Shouldn't the builder and he be signing an agreement straight away?
You see, Manisha, the problem with these tripartite agreements is that at the initial stage, the builder tends to, sell off the flat to an investor. Now, if you look at MOFA, the Maharashtra Ownership Flats Act, which is the governing law for the builder and the buyer agreements, whenever a builder even accepts 1 rupee from you as an advance, he is supposed to sign an agreement and register the same. Now, this is something which is the law, but is observed more in the breach. I don't know of a single builder who does this. So what happens is, when the investor comes, the builder generally just gives a letter of allotment and the guy stays invested in till such time as a genuine buyer comes along. Now once the genuine buyer comes, that is when the builder formally makes an agreement with him. This is, you can say that it's an evasion of stamp duty in very plain terms. So what happens is that that point in time, the money has already been received by the builder. So now whatever the buyer is going to pay, the money must actually go to the investor. However, since there was no title with the investor, who is going to pass the title? The title has to be passed by the builder. This is how these tripartite agreements came into vogue. Now, technically, these are illegal because the law is very clear. When you buy a property, you have got to sign, execute and register the agreement. At the same time, there is a lot of evasion of stamp duty happening. Now, if you know, in October 2011, the Supreme Court passed an order in the case of Suraj Lamp and Industries, making it very clear that where registration is a must, you must do it, and if you do not do it after this particular date, title is not going to pass. So having said that, you will realize that a lot of government agencies have accepted this tripartite agreement practice. So if the builder is going to transfer to him, probably at this stage there will not be an issue with the title. But what could be an issue is that at some point in time, the government would have the right to demand stamp duty on the first leg of the agreement. So that might be a possible liability for the buyer, which Gaurav needs to consider.
So he should just make sure that he finds out who will bear the stamp duty, and in this case it should be the developer.
Absolutely. Anyone except
All right, Gaurav. Okay. Gaurav, your second question?
So my second question is, because the owner is leaving India in next month in February, outside India. So, and I am trying to finalize this agreement in April 2013. So my question is whether the owner will become an NRI in this time, and what will be the tax liability in that case?
Oops. Okay. Another very interesting question, Vinay. This is not a straightforward one at all. The owner's leaving India. So what does he do about the tax deducted at source?
Well, there are two definitions of for non-residents as far as two different laws are concerned. There's a different definition under the income tax law, which says that if you're out for more than 182 days in a financial year, then you are considered as a non-resident. But FEMA, which is the Foreign Exchange Management Act, treats this differently. The minute a person leaves India and there is a clear indication that he wants to live abroad and work abroad, for an indefinite period, then immediately he is considered to be a non-resident. Now, once that happens, if you are going to make any payment to the seller, it becomes your duty to deduct tax at 20% plus cess, which would be 20.6%. So you have to deduct tax on the full amount that you're paying to him. Of course, there is a way out. If the seller decides to go to his jurisdictional income tax officer, he could obtain a certificate authorizing Gaurav to pay him the monies either with no deduction or with a lower deduction of tax. Now that will depend on the facts and circumstances of the case, his tax liability, whether he wishes to save tax by investing in either bonds or another property, etc. But this is possible. However, a note of caution that this liability is Gaurav's to deduct, and if there is any failure to deduct the tax, the consequences, the penal consequences, all will be applicable to Gaurav.
All right, Gaurav, we're going to take your loan question as well now. The rest of it, I think we'll have to answer on email. So you had some pertinent question on outstanding loan amount as well with the existing owner.
Yes. So, my question is, currently the owner has an outstanding loan from HDFC. So he wants it to transfer it on my name, and I am planning to get a loan from HDFC. So what's the best way and what precaution I should take?
All right. Vinay, generally loans don't get transferred. They're basically settled and then you just have to take a fresh loan, but it can be with the same bank if I'm not mistaken, or the same finance company.
Yes, very true, Manisha. Loans cannot be transferred. The original loan account will have to be closed. Now this could be done either by the seller doing it with his own resources, or even Gaurav could make the payment directly to that institution and close the loan and get a letter confirming that there are no dues. Either ways it is possible. And also, yes, it would make life a little simpler if he takes a loan from the same institution, because they are already aware of the paperwork, they already know the facts of the case and the property. So to that extent, they will not have an issue with the due diligence. So probably it might be a good idea to go with the same institution.
All right, Vinay Singh, thank you very much. Gaurav, I hope we've been able to answer your question satisfactorily. There is one more question which you'd send us by email. We'll send you the reply. We've run completely out of time on this expert segment. Thanks, Vinay, once again. Okay, we've got